Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Welcome to the Kentucky Auto Accident Podcast with attorney Jim Desmond of the Desmond Law Office right here in Louisville. My name is Jim Ray. I'm co-hosting with Jim Desmond. I'm a non-attorney spokesperson, so again, anything I say during this, you don't have to listen to, but Jim Desmond's the guy, and he's on the other mic here, and when he speaks, you might want to listen. He's been doing this for 20, 25 years now, and has a really good background. So, Jim, we're in episode 2, so congratulations. We recorded episode 1 recently, and that's up and going. So, do you want to do a quick recap, or do you want me to have a recap of where we were last time?
Well, go ahead and hit the recap. I think, what did we hit? We hit a lot of stuff about everything from property damage to the overall concept of needing an attorney versus trying to represent yourself. What else am I missing, Jim?
Well, we talked a little bit about Kentucky being a no-fault state and the fact that you've got $10,000 worth of coverage. If you have auto insurance in Kentucky, you've got that. We talked about, there are 3 aspects: property damage, medical bills, and pain and suffering. And about what you enjoy more about being a solo practitioner or a solo attorney versus working for a larger firm or working in various areas, different ways people can hire attorneys. They can call you directly, talk to you directly on your cell phone, and basically not have to worry about getting passed around. And again, one of the advantages of working with you at the Desmond Law Office. Jim,
let me cut you off because I want to throw in another nugget. You bring something up, and I'm like, I cannot let it go by, because and actually, unfortunately, even attorneys get this wrong. You mentioned earlier, yes, Kentucky is a no-fault state. Okay, if the accident happens in Kentucky, and your vehicle is properly insured, or you're in somebody else's vehicle, or you're on a TARC bus, you're going to get the no-fault coverage, okay? That's a really simple rule that everybody messes up. But if the accident happens in Kentucky, you're entitled to no-fault coverage unless you're driving around in a vehicle that you own and you didn't have insured.
And you kept saying in Kentucky, you're also licensed in Indiana, and that system over there is a little bit different than what we have here, right? We have a no-fault, we have that PIP, personal injury protection, but in Indiana, it's different, right?
In Indiana, it's MedPay. And the real difference is this. Well, no fault can cover multiple things. It's medical bills, lost wages, replacement loss services, and 2 other elements. We don't use that often. And it's automatic. When you hear that, immediately somebody can get you $10,000 for a car wreck, that's all they're talking about is no fault insurance, okay? MedPay is medical expense coverage on your own policy that you purchased prior to the accident, before the accident happened. Usually it's $5,000 or $10,000 you purchase. And
that's something you've got to pay for. You've got to select that coverage. You've got to.
Right. It's not mandatory. It's not required. You could say, I don't want to have it. I would tell you still to have it for a lot of different reasons I would tell you to have at least $10,000 again, but.
Okay. Well, I tell you what, in episode 2, we're going to have a number of segments here. And I just want to encourage everybody, if you're new to a podcast, understand that you can subscribe to a podcast, and podcasts are free. They don't cost you anything. So if you see a subscribe button when you're listening to this podcast or whatever app you might be using to download it, by all means, subscribe to it. And all that really does is let you know that there's a new episode available for you. Again, a podcast is not something that's going to add you to a mailing list. If you subscribe, it's not something that's going to charge you. It's a notification so that if you liked what you heard, hey, here's another episode, so you can follow along.
On that issue, Jim, we didn't do something in the first one that I kind of wanted to. One of their means of contacting me is just my email, okay? It's the letter J, and then Desmond is DESMOND, and it's ATTY@yahoo.com. So you put that all together, no periods, no underscores, J Desmond, ATTY@yahoo.com. When you hear these hot podcasts, if you want to send me an email, feel free. If you want to hit a comment or a question, feel free. If you guys have questions down the road that we're not addressing, let me know. I'll be happy to take some time, research it. I may not know the answer, but we'll see if we can find it out ahead of time and kind of give you a little bit of guidance. So,
absolutely. So I tell you what, in this episode, let's start out with assuming the collision has already happened.
Okay.
And so I'm sitting at home, I'm injured, and suddenly I get an insurance agent calling me and saying, hey, we want to just take a quick recorded statement, and we just want to kind of get your fact basis and kind of understand what really happened. Would you mind sharing that detail? Should that throw a red flag up for me?
I don't know if I'd say the term red flag. I do cringe a little when I hear recorded statements. Nobody likes them.
What are they, and why are they asking?
Well, and that's just it, okay? You always have to understand, an insurance adjuster is not a bad person, okay? But they have 300 or 400 files that whatever they do in that file, they close it out, let's say 6 months from now. 3 years from now, they can still be audited and they can go back and say, why didn't you do this? Why didn't you do that? So a recorded statement is their chance to investigate your accident, your injuries, get it in writing, put it in the file, which is a good thing if it's required or necessary. One of my problems is like when somebody calls and says, I want to do a recorded statement with your client, my first response is, why? What's the point? If you have a potential case of disputed liability as who's at fault, sure, I can understand that. If you have somebody, if my client's own insurance company is a no-fault carrier, that's all they're going to be, and the other person rear-ended them, it's real clear that my driver was not at fault. Why am I going to give a recorded statement? Okay. Now, this is the bad part, especially if you represent yourself. And I'm going to get a little complicated here for a second. You always need to know which insurance adjuster you're dealing with and which insurance company. And what I mean by that is, are you dealing with first-party coverage, which that's what the coverage you purchase, okay, or third-party coverage, the coverage you're making a claim against because you're saying someone else is at fault? Because if you think about it, the duties of an adjuster under first-party coverage are to you. You basically paid for their time, their responsibility. You have this contract. That's what you did.
So if I have ABC Insurance Company, the first party is my rep, my carrier, my company.
And in theory, they should have their duties and loyalties to you, because what are they trying to do? They are trying to defend you under that policy. They're trying to make sure you're not at fault. And the one reason why would they want to do that? Think about it. If you're at fault, they've got to pay. Okay. In contrast, if the adjusters for the third party insurance, the at fault party, okay, what are they trying to do? Just the opposite. They want to minimize your claim. They want to show you're at fault. That's all these ways they can do that. So one of the things that I hate these days that I see a lot, insurance companies will try to bully you into a recorded statement and say it's required under the contract. And there is some truth to that, but it is not completely true. So first thing I always say is, why do you want it? Okay, give me a good valid basis. I'm not going to just do it normally. Second thing is, I'm probably only going to let my client do one recorded statement, and then that statement can be shared with the other person's insurance company if it really is required. If you decide to do one and you say, okay, I'm going to give this adjuster one, that's fine, but I want you to remember some things. First of all, you don't minimize your injuries, okay? It's kind of like the criminal law where they say anything you say can and now will be used against you in the court of law down the road. It's the same concept. So you don't minimize your injuries. You don't guess. You don't hesitate to say you don't recall. You don't let people put words in your mouth. And you keep it brief. I always tell clients the other thing is answer their question. Don't go to a lengthy answer. If I ask you what time it is, the proper response is really yes. Or I'm sorry, if I ask you, do you know what time it is? The proper response is yes. It's not 4:30. All right. That's why you got to be very specific as to what you're saying and doing.
Because they're trying to trip you up. They're trying to get you to admit to something. They're trying to do something that's going to help them down the road. It
depends. I don't want to say that. I don't want to speak badly of insurance adjusters that way. It depends upon what their loyalty is. Who are they representing? I did have one the other day that I did chew out an adjuster because, Progressive was his insurance company on both sides. Okay. They would have been the first party and third party coverage. And I had a third party adjuster saying to me, well, my client has an obligation to do this recorded statement under the contract. I'm like, no, they don't. They don't have any contract with you. Your duties are completely separate. So I don't want to say they're trying to trip anyone up. They're trying to investigate the claim. But ultimately, let's face it, any insurance company, what's the job of an insurance company? To pay out the least they can on a claim and get it settled and move on to the next one.
Well, if I get one of those calls, could I call a timeout and say I'd like to have my attorney present?
Sure, absolutely. I'm always on the phone with a recorded statement. Let me give you another little nugget, and I'll badmouth attorneys, unfortunately, here. If you are already represented by an attorney for a car wreck, and they want to do a recorded statement, I'm not talking a deposition, okay, that's litigation, a recorded statement, have that attorney be on the phone with you and either do a three-way call or go into their office and do it in face-to-face. Don't let a case manager handle it. Don't let a paralegal handle it. I'm sorry. I think that attorney should want to be there because they should want to hear what you're saying, how well you're going to come off as a witness down the road, what the facts of the accident were. And that way I can also fill in some blanks in my file. If I notice when I first met with a client, I forgot to ask him about XYZ, I've got a chance to do it. I don't believe in delegating that to paralegals or case managers. I just think that's wrong.
Well, Jim, when it comes to these types of collisions, these types of accidents, it always comes down to who's at fault. And obviously, the guy who hit you is going to say, well, it wasn't me. You did something. And I'm going to look at you going, no, I had the right of way and I'm clear. You hit me. You ran the red light or whatever. Let's talk a little bit about that.
Okay. Little side note again, I was investigating the other day that I like radar detectors and I may replace my current one. And now they are combining them with video cameras, by the way, for the roadway. It's kind of interesting, which is not a bad idea if you think about it, because again, you have somebody saying you're at fault for an accident and you got a video showing, no, I didn't do that. That's kind of very persuasive. First thing on that, call a police officer, get an accident report. Okay. Yes, you can do an accident without one. It's a whole lot easier and a whole lot more persuasive to have that information there. Police reports are not admissible as evidence in front of a jury, okay? But they do persuade insurance companies right off the bat. And he might also take a look and say, who has the right of way? And that's what you were getting at, Jim. 90% of the cases in Kentucky or Indiana are determined by who has the right of way, okay? So when you're driving, when I'm driving and I turn left in front of somebody, I don't hesitate to give it gasoline, because if I'm turning left, I'm at fault, period. People will say, oh, the other guy was speeding. Okay, maybe he was speeding, but that's what we call comparative fault. I'll explain it in a second. The primary fault is going to be on the person who failed to yield the right of way to the other vehicle. And who was that? The guy turning left. If I rear end somebody, 90% of the time, I'm going to be at fault. Again, I failed to follow at a proper distance. That's really the way to drive, is if you think about it. On myself, I'll tell you one of the times I made a really dumb error almost, and luckily I didn't end up in an accident. I'm pulling out of a gas station, and I have a guy coming up, from my left-hand side with the right signal on, like he's going to turn in. I trusted the signal, and I pull out in front of him. And the short story was, luckily we avoided the accident, but it would have been a pretty bad one. Again, who had the right of way? He did. I'm entering his roadway. Okay, he had the signal on. Okay. That was not the smartest thing. That might be a basis for arguing what we call comparative negligence. But again, the primary responsibility lies with me. I want to go back to comparative in a second here, but I want to hit one more little example, and that I always hear. You're pulling out of anything on the side of the road, and traffic is stopped, and you're waved across traffic by a driver. You've got the duty to basically make sure, again, you've got the clear path to get in the traffic. You don't have the right of way. The other vehicles do. The fact that somebody waves you on is irrelevant.
Interesting. So they're just basically saying, hey, I'm gonna allow you to come across, but they're not waving.
You can't rely on somebody waving you. You still have to make sure things are clear. That's the bottom line, is because again, when you drive with the concept of who has the right of way, it makes a huge difference, because again, I cannot putt along as I'm doing a left-hand turn. Okay. I've got to follow at a safe distance, because again, there's nothing. The guy slams on his brake for a squirrel in front of you. You rear end him. You're going to be at fault. Simple as that. You're going to be at fault. You can get upset. You could call me. I'll tell you that. You get upset with me. You call a different attorney. 95% of them are going to tell you the same thing.
Well, let's come back to that topic of comparative fault, comparative negligence. How does that come into play?
Kentucky is what you call a pure comparative fault state. Indiana is what you call a modified comparative fault state. Okay, Kentucky, the gist of that is, okay, you're 99% at fault for an accident, you can still recover 1% of your damages. Basically, pure comparative fault is saying whatever percentage you're not at fault for, you can recover your damages.
And who makes that determination?
Well, ultimately...
I'm gonna blame you.
Yeah, so everybody else does too. Ultimately, that's a jury, okay? If you get to that point. In the beginning, it's going to be arguments between insurance companies, adjusters, and attorneys. Okay. But if ultimately you got to go all the way, that's where it would go. Indiana is called a modified comparative fault state, which means you cannot, if your fault is equal to or greater than the other driver's fault, you can't recover any money. Okay.
Really?
Yeah. Your claim is barred completely. So if you're 50-50, you're out of luck. Okay. In Indiana.
So you're on your own for your car, you're on your own for your bill, your medical bills, any of that.
Yeah, pretty much. Yeah. Think about it. Well, yeah. Because it would be as if you ran down the road and hit a tree. It's the same concept. Yes, if you're the majority at fault, then you're going to be in trouble in Indiana, okay, or equal to. The modified comparative fault. This is the part I want people to understand a little bit, and this is where it runs into problems. Is you get in, especially if you don't have an attorney, and you get into a situation where, well, I got one right now where they want to try to argue somebody's 20% at fault, even though she had the right of way. And I'm trying to remember what their basis was for arguing it. But now we're in a position where I've got to fight that case, because if we agree to it, okay, then they also have a claim against my client for that 20% of their damages, okay, their medical bills, everything else. So we're in, well, I got another one. I've got deposition next week that we're in litigation because they tried to argue 15% fault against my person, okay? And the other, I've talked to the defense counsel, and we both know it's just kind of a malarkey type argument, but in the same respect, that's what you got to watch out for.
But so, I mean, that sounds so arbitrary. No, you were 19% at fault. I mean, who actually makes that determination? And I guess that's what you're trying to negotiate.
Saying, you're hitting on the nose. It can be very arbitrary. That's the thing. That's why back to recorded statements, you want to be careful what you say, because you say, yes, this other person pulled out in front of me, and you say, but I was looking down and I wasn't doing that. Well, that's a basis for 20% at fault. I mean, an insurance company can argue. They can dispute a claim or argue fault as long as they have a reasonable basis in law or fact is basically the standard. So, excuse me.
And guys, I'll apologize. We're both battling some allergies here. So if you hear a cough or something like that down the road, again, we'll try to edit out what we can, but we apologize for it. So let's assume it was a pretty bad wreck.
Okay.
And the insurance company wants to total my car. And I'm thinking, well, I really like this car. Maybe I can just kind of get it repaired. Talk to me about that. I mean, how does that decision get made? What's the process? What's that about?
First thing, take pictures of the damage to the car and be picky about it. Look at the seams and everything else. The damage to a car is usually, insurance companies try to equate that to how badly you should be injured. So it does help down the road. But what you're talking about is a total loss. Okay. If the repair cost for that vehicle equals 70%, actually it's 70% of its fair market value, what the car is allegedly worth, okay, they're required by law to total it out. Now, that's the lousy part. So, well, I'll give you an example. I bought an old Explorer from a friend of mine that has 250,000 miles on it, and I've already probably put too much money into it. But it is a good running car that I probably can get 2.5, 3 years out of. Book value on that car is maybe $1,300. So if that car gets into any accident, they're going to say, it's not worth anything, and they're going to total it out. And all they're going to owe me is the $1,300, even though it's going to cost me $5,000 to replace it with a good SUV.
So again, it's fair market value. It's not replacement cost.
Correct. And that's the part that's unfair. That's one reason sometimes people come and make a personal injury claim, because, again, it's horrible to say, but they kind of have to make it up where they can make it up. And I don't mean that they make up a claim, but I mean make up their financial loss. That's why they have to do it, because the law doesn't fully compensate them right off the bat.
And I mean, as an owner, do I get a say in any of this as far as, okay, this is cut and dry. This is whatever the insurance company.
Well, you can choose where the car goes. Okay. There's nobody can force you to take it to any particular body shop. Okay.
All right.
And you are entitled to loss of use as well. A loss of use is the equivalent of a rental car, or that if the car is not drivable. Okay. So if a car is a total loss, I usually find loss of use is about 10 to 14 days at $25 to $35 a day, somewhere in between there. Okay?
Which would be a standard rental.
Yes, unless you have the rental car instead. Okay. And we always have those issues. As a matter of fact, on that issue, another nugget for people to, when they're saying you got to return the rental car, but they haven't given you the check for the property damage. Okay. Especially if you've already agreed to it. Okay. You can try to use that as a basis sometimes to extend the rental car. It's a long story, but a little nugget there.
So you still have a little bit of leverage because they're kind of paying for it.
Well, they have to, they're paying for the rental car if they're at fault. They're only going to pay for it if they're at fault. Okay. Right. But it gives you a little bit longer with it if it happens. But no, you have no choice if the car is going to be totaled out or fixed. If it is fixed, you do have a diminution in value claim. Everybody ignores that. And it's a hard claim to present because you got to show the claim is the diminution in value claim is that the car is worth less because I knew it was in a car accident.
So if I do a Carfax report on it and I'm thinking about buying your car, but I realize, this thing's been wrecked before.
Yeah.
Again, it's not worth what it might look like.
Right.
Because of
But you got to have an expert tell you that. And that's the problem. But again, you can potentially make that claim as well. I kind of feel like we're doing an injustice to property damage, and that's because it can be so complicated, and yet it should be one of the easiest aspects of the claim, but it's not, especially because people take care of their cars and they want to get as much as they can for it. If it's a total loss, let me give you a little couple nuggets. get your title together, get together all the repair receipts you have. Insurance companies will say that doesn't increase the value. I don't care. I'll try to show it's in as good a shape as possible. If I'm going to argue with them about the value of the car, I go get a basis for arguing. Go to cars.com and pull up that car within 100 miles here and what the dealers are asking for it. Go to edmunds.com and see if there's a higher value.
Like a Kelly Blue Book? I mean,
exactly. And Kelly's tends to be high, but exactly. You've got, back to what I said in episode 1, which was you got an insurance adjuster who may want to agree with you, but you're one of 400 plus files that they're handling. They've got to document their file knowing it could be audited 3 years from now. So again, if you're going to say it's worth more because it has these rims on it or something that most of these cars don't, or because it had tinted windows, show them the receipt, show them your cost, show them what it would cost to put that on a new car, and also show them why that car, a dealer, might be asking more money for it. So,
okay. Well, okay. So let's assume then we've had an accident. We both get out of our cars and we're talking. And the guy who actually rear-ended me says, well, actually, no, I'm not going to accept fault. It wasn't my fault. You did this or you did that. So now we're in kind of a he said, she said. We're in a situation where things just got really, really complicated because nobody else was around. The police officer who's going to do the report wasn't even around. Let's walk through that. I mean, what are some of the factors we need to be concerned with there when the negligent driver says, I'm not accepting fault for this?
Well, and luckily he doesn't get to determine it for the most part, but I'll come back to that in a second. You just described a scenario where you were actually at the accident scene. And I always say this sounds so insensitive, but if you're at an accident scene and you're not hurting to the point where you need an EMS, an ambulance, take out your phone and take pictures. Take pictures of the placement of the vehicles, how they hit before they were moved, the damage to them, a picture of his license plate, because especially in Kentucky, I can run a plate. In Indiana, it's very hard to do, but I can run a plate and get some insurance information off of it. But a picture, again, is worth 1,000 words. And again, what people fail to understand is, okay, from the minute that accident happens, you're trying to get ready for the possibility that you could be in a lawsuit a year and a half from now, because again, you have somebody saying it's not their fault, even though it was their fault, and we know it was their fault. And
again, evidence is important. I mean, you're going to forget things 3 days from now. You're going to forget things 3 months from now, much less a year and a half.
That's why I tell all my clients, I say, send me everything you've got, every medical bill you get, every photo, because nowadays with these clouds, that's what I do is I scan everything to a cloud. It's saved to a cloud. It's there years from now if I need it. Okay. What happens more than at the scene, because the officer makes his determination if he can and puts it in the police report as to who's at fault, it's after the fact. So now you got his insurance company saying, well, my insured says he's not responsible. And they're not required to accept the position of their insured. Okay, the insurance company has a duty as well as an obligation to make their own decision, but they may back up their insured. If you have where you usually see what you're talking about, Jim, is, who has the red light? That's the big thing. Who has the red light? Who has the green light?
Well, it was green when I went through.
Right. And on that issue, I'll give you another nugget. If you are at an accident scene and somebody says to you, I saw it, you get their name and their phone number and hopefully their address, but at least their name and their phone number. You keep a copy. Yes, give a copy to the police officer, but do not rely on the fact that he's going to put that in the police report. Okay. But you're in a position now where all of a sudden you're getting, you're making your property damage claim. You think it's a rear end collision. Now all of a sudden you got somebody trying to argue you're at fault. Well, now what do? Okay. Because you're sitting here saying, I don't want to accept any fault, but they're trying to say that somehow, back to comparative fault, I'm 40% at fault because I stopped too quickly. Some kind of ridiculous argument like that. One scenario, use your collision coverage on your own vehicle. Okay. People don't like to do that. They don't think they're at fault, but the downside is you get stuck with your deductible. The upside is you're not accepting any fault from the other person to get your car fixed, and you're getting your car fixed fast. Because what you got to realize is if an insurance company is let me take a step back. If there's nothing in the law that really requires an insurance company to settle your claim. Okay. Now that is an oversimplification. And yes, attorneys can start screaming bad faith to me and all this other stuff. It's a very hard standard to make a bad faith claim against an insurance company. Okay. Excuse me. If an insurance company has a reasonable basis in law or fact to dispute a claim, they're in good shape. They're covered. So you got a red light case. Okay. And their driver is saying you ran the red light or that you entered the intersection on a yellow. That's a reasonable basis to dispute it. Well, how do you get around that? You may have to be in a lawsuit. Well, a lawsuit's a 1.5 year long process where a personal injury attorney doesn't want to touch it, okay, unless there's a personal injury claim with it. And even if he does touch it, he's going to charge you probably a 40% fee on it. And to even file that lawsuit is roughly $300, okay? That's what the county clerk charges us. So I feel like I've done an injustice a little bit to what you brought up, but it's a very complicated situation. But the answer is, yeah, if you're in a situation where potentially the other person is disputing fault, you want to fall back again and use your own insurance as much as possible to kind of get around that for the moment. Now, maybe down the road, they'll come around. I did have a case recently that happened. It was, they disputed it to begin with. We had to go through a lot of arguments. I had to hire an investigator and get a witness statement. But 60 days later, we got the car taken care of. I mean, and the client didn't have collision coverage. So that was the lousy part. But again, what were my options? And let me say one more little thing on this. I can file suit against somebody tomorrow. Okay, that's not a big deal. All right. If I file suit from the time they get served with the complaint that I filed with the county clerk, okay, or actually the circuit court to be more correct, they've got 20 days to file a written answer. Okay, and then the whole litigation process kicks in. So it's not like if you file suit, everybody jumps up and does something. If anything, it slows the whole ball down.
And luckily for most of us, the majority of these cases never go to court. I mean, they're usually settled before they get there. One is more efficient. That it's just some cases don't need to go all the way to court to get resolved.
Well, you know, the thing about that's always interesting because the media doesn't portray this. The media always does the ones that the high publicity ones or something that sounds bad, like the coffee cup case or something like that, even though it wasn't as bad as everybody's thought. It's insurance companies aren't dumb. They settle the cases that should be settled. Okay. The ones that have high risk and such. But the other way that, again, how do you keep your case from being or how do you keep your case from going to court and make it one of those that can be settled? You document everything, okay? From the accident scene, you take the photographs. You've got the witness statement. Your injuries, you go get the treatment you need. You take away that ability for somebody to doubt your claim, whether it's fault for the accident or how the accident happened or your injuries or what's related. You take those things away, and then you're in a good position because think about it. What are you really trying to do? You're trying to go to bat and hit a ball, okay? That's what a personal injury settlement's about, is trying to hit the ball out of the park if you can. Well, the better the bat is, the better chance you have of getting it out of the infield.
That makes perfect sense. And this assumes there's insurance. Now, in episode 1, we talked a little bit about this. There's no guarantee that even in the state of Kentucky, that driver's going to have enough insurance to fully satisfy your claim.
Right. Well, and actually there's two concepts. One, everybody is supposed to legally have insurance. We all know that. Okay. About 1/3 of the drivers in Kentucky, I think the statistic is about 1/3, they drive around unlawfully and don't have insurance. Okay. So now somebody doesn't have insurance. I have to make a claim. Well, I can't make a claim against them. I can, I guess you could say. But again, I can't get blood from a turnip. And if you're driving around with no insurance, you don't have a house to go against. You don't have a Mercedes in the garage that I can collect, the judgment against, and that's all a piece of paper is. That's all a judgment is a piece of paper that says you owe my client money. So I go through a whole lawsuit. I get a piece of paper that says you owe my client $50,000. Well, if they don't have $50,000, it doesn't do any good. They don't have any insurance to pay the $50,000, and they go file bankruptcy, and boom, it goes away.
So what's my option?
Back to your own insurance again, and you kind of brought that in on another aspect. On your own insurance policy, I always say there's 3 coverages that really protect you, okay? The first one we talked about a little bit, which is no fault. It's automatic. You can buy optional. If you can't afford it, fantastic. If you can afford it a little more optional, buy it. The 2 mandatory ones I say are uninsured and underinsured coverage, okay? Uninsured, guy has no insurance, your company steps in, and they act like they insure this other driver. Whatever they pay out, okay? So that same accident scenario I just gave you. We go make a claim and they pay out $10,000 on your behalf. They go sue this guy and try to get their money back. And of course, we know an insurance company, they can handle a $10,000 loss. Most of us can't. They can. Underinsured is what you referenced a little bit before, which is, okay, this other guy had insurance, but he had $25,000 in coverage and I got $60,000 in medical bills. As a good personal injury attorney, we can collect we can collect his liability insurance, hopefully his policy limits of $25,000, and then go make a claim against your company saying, hey, my client's claim was worth more money than this $25,000. And I want to make a claim for this underinsured coverage, saying my client was not fully compensated.
And Jim, I'll give you a compliment on this. When we first started working together, probably about 10, 12 years ago, you looked at my policy for me and advised me to go out and talk to my agent and get my UIM, that underinsured motors, raised up significantly. It was the cheapest insurance I could buy. I mean, I'm surprised they didn't talk to me about it, but they weren't making any money off of it. But for hardly anything at all, I doubled what I had. So now if somebody does hit me and they're uninsured or underinsured, I'm covered. So thank you for that. I mean, great advice. And I tell everybody.
On that, I'll put my money where my mouth is, because my policy renews in January, and I looked at it the other day, and it wasn't too bad till I had to put my 19-year-old daughter on the policy. No accidents, even no tickets.
Right.
Still shot it through the roof. But I looked at it again the other day, and I mean, I've got $500,000 per person of uninsured and underinsured coverage. Okay, and I think each coverage for the year might have been $200, $300 most.
Right.
And again, if I call my company and say, hey, what would I say by dropping it down to say 100,000 per person? It might be $50, $60.
It's just not worth it.
It's not worth it. It's not worth the risk. And granted, I understand I'm not going to use that. God willing, I will never have to use it. God willing, I never have to use it. Okay. But if anyone in my family has a severe accident, it's covered. It's there. It covers things. And I want to stress something that people, I think, overlook a little bit. I like to do a lot of driving, and like a lot of family trips, we'll drive down to Florida and such. That coverage follows you, okay? The general rule is that the site of an auto accident, where the state it happens, that state law controls how the accident happens, okay? Or the comparative fault issues and all these other things we've been talking about. But my coverage, okay, what I paid for, my uninsured coverage, my underinsured coverage, that no-fault coverage, it follows me no matter where I go, because that's a contract of insurance that I paid for, and basically I'm entitled to.
Yeah. Again, I can't thank you enough for that. It's one of those little things that, because a lot of us like to buy insurance on price, what's the lowest premium I get, we forget, no, coverage is important when you need it the most.
Right. And the thing about that, again, on price, is most insurance agents will send you out with, and legally there's no such term as full coverage. They'll send you out with a policy that they'll say it's full coverage. Well, what they're doing is they're selling you $25,000 of uninsured and underinsured coverage, which is good. But the part that everybody ignores is that, okay, for maybe, $30 on each of those or something, you could probably bump it up to $50,000 or $100,000, because again, you're paying the majority of your insurance premium for that first part, not the second.
Well, tell you what, at this point in the episode, let's go ahead and transition to this. And it's a segment we try to use each episode called "So This Happened This Week." You had an interesting case that came through the door. Let's talk about it.
Yeah, and actually, ironically, it talks about uninsured and underinsured and everything else. First of all, my client was on a motorcycle. Okay, well, guess what? Let's say you take, I'm laughing because this is how ironic the law can be. You listen to everything we say, you listen to everything we do, and you go put this kind of insurance, uninsured and underinsured coverage on your automobile, and you don't put the right kind of insurance on your motorcycle, we're out of luck. Or not potentially. We'll look for it, but there's an exclusion usually under the automobile insurance saying while you're riding your motorcycle, we're off the hook. Okay. Wow. So that's one of the first steps. But yeah, it was an interesting case because car pulled out in front of my client. He laid down the motorcycle, so there was no contact between the two vehicles. Okay. Car went on. Okay. His own insurance company tendered the limits of his uninsured coverage, which in fact, they really should not have. Okay, I wasn't going to tell them. It's not my responsibility.
So let's not mention the carrier.
No, we're not going to. Okay, because uninsured coverage requires physical contact between vehicles. And you think about why that is. Because they don't want me to run down the road, have had 5 margaritas, run into a tree and say, oh, somebody ran me off the road. They want physical contact to show that I'm not making a fraudulent claim. Well, the short story was we also hired an investigator. And they went around and they found, through one of these Ring.com cameras, they found the actual video of the scene, okay, the accident when it happened. That investigator, one of my best I got, she actually found you should not have been able to see that car from this video, okay? I mean, in the sense we couldn't see a plate. I'm pretty much a car guy. We still couldn't even find, to figure out what model it was. Well, she's over in that area, and she's like, that's that car. That's that car in that video. So she goes, knocks on the door, finds out the name of this driver. We go, take all that information. We go back to his insurance company. He doesn't think, back to what you said earlier, he doesn't think he's at fault at all because he never made contact. The insurance adjuster agreed with me. Nope, he's at fault. Well, That coverage now is liability coverage. Well, two things. One, it was higher than the uninsured coverage that we were collecting. So fantastic. We had to give back that uninsured coverage. That was actually the second aspect, because now we recovered more money, but also we're not dealing with an uninsured vehicle. So we had to send back the uninsured check, okay, which was okay. We hadn't cashed it. It was no big deal. We recovered more money that way by making a liability claim. The part that kind of still stinks is the motorcycle coverage did not have underinsured coverage on it. Again, and remind me of a nugget in that in 3 seconds. It didn't have underinsured coverage on it, so we were done at that $50,000 rather than being able to recover more money for our client. Because once we hit that policy limit of the liability coverage of $50,000, we could have potentially done more. Okay.
What was the nugget you were referring to?
And I just went blank. I know I want to.
Did it have to do with motorcycle coverage itself?
And I just told you to remind me, and I wanted to go back to that immediately.
Well, we talked in episode 1. We talked about no fault coverage, this PIP coverage, but that does. And just because I have a policy, I automatically get that $10,000 worth of coverage. That's not always the case with motorcycle insurance.
No, and actually, that's very close to what I was thinking. The other aspect we had on a motorcycle is motorcyclists are not treated fairly. Okay, if medical bills could be paid under no fault coverage, you didn't have insurance on your vehicle. Okay, but for that you would have had your medical bills paid up to that $10,000, right? The law says we give up the right to recover the first $10,000 in medical bills. It becomes the right of the insurance company. Okay. If there's no insurance company there, we still give it up. So in other words, if it could be paid as a no fault benefit, okay, then we give up the right to recover it. Well, the reason I'm going there, and everybody's looking at me like I'm crazy, motorcyclists right off the bat cannot recover the first $10,000 in medical bills. They treat basically a motorcyclist as if they're uninsured because it's considered to be a dangerous vehicle. That's what the Motor Vehicle Act does. If anybody wants to, a little nugget on that, everything in Kentucky is governed. It's called the Kentucky Motor Vehicle Reparations Act. It was passed in 1976. It's not actually that hard to understand. If you want, Google that. It's called Abolition of Tort Liability. But it basically says, again, if you're on a motorcycle, as soon as you get on it, you cannot recover no-fault coverage. And the driver of a motorcycle, here, I'll give you another nugget. The driver of a motorcycle cannot recover the first $10,000 of their medical bills or lost wages, even though they were not at fault. The one part most attorneys screw up is the passenger on a motorcycle cannot recover no-fault insurance, okay? But they can recover their medical bills from the at-fault driver, okay? There's an exception for that, and most people get that wrong.
And that's the passenger only, not the driver.
Correct. Wow. And you gave me a little sign, but if I got 30 seconds, I want to add one other thing here on motorcycles. Pedestrian PIP. You will see on your motorcycle policy something called pedestrian PIP. All that means is that if your motorcycle hits someone, okay, that person is entitled to recover that $10,000 of no-fault coverage from your motorcycle insurance. It does not cover you or your passenger, okay? And that's the lousy part again. So because everybody sees that pedestrian PIP, and PIP, no fault, same thing, and they think they can recover that. Nope. It means if you hit a pedestrian, we're going to pay his medical bills up to $10,000.
Wow. Jim, thanks very much for episode 2 here. I love doing these episodes with you. Let me ask you this. If I'm listening to this and I want to contact you, there's a couple easy ways I can get a hold of you. You gave us at the outset, you gave us your email. Mm-hmm. Okay. Give us your website, your phone number. What make it easy for us? And
we missed one thing in session 1, I'll tell you, but attorneydesmond.com is the website. Okay. There is a Facebook page as well that I believe is under Desmond Law Office, or Jim Desmond is my personal page. Either one you could reach. What I would encourage more than anything else is my cell phone is 502-609-7657, 609-7657. Something I forgot to mention in episode 1 is if you want, text me. I don't care. Text me the question. Okay. I'm happy to, respond to texts and such like that. Some people don't, they feel a little intimidated talking to an attorney right off the bat. I'd like to probably know more information than you can give me in a text, but send me a text, an email, make a phone call. It doesn't matter. Usually the cell phone is mostly 8 a.m. to about 10 p.m. at night.
Perfect. And again, I'll encourage you once again, if you're just finding this podcast and you like what you've heard, by all means, subscribe to it. Won't cost you anything, but you will get a notification in about 2 weeks when the new episode comes out. Thanks
and if you have comments or questions, let us know. I want to follow up on that. I want to see what questions we're not anticipating. So
Absolutely.
Poor Jim's like, I need to cut this off, Jim.
It might turn into another podcast session for us. So it'll all work out. But hey, thanks for your time. I appreciate it. Jim, thanks for your time. And that's a wrap for episode 2.
Thanks. Good talking to you.
That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely and please remember to buckle up.